as delegates or being voted for as candidates in party conventions or congresses. The contested section reads, no political appointee at any level shall be a voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election. In other words, if political appointees want to contest elections, they must first resign within 90 days. But delivering judgment on the suit challenging the constitutionality of the provision, the judge, Evelyn Anyadike, held that the section was unconstitutional, invalid, illegal, null, void, and of no effect whatsoever. That's a mouthful, wouldn't you say? Judge Anyadike ordered the Attorney General of the Federation to forthwith delete the said subsection 12 of the Section 84 from the current Electoral Act 2022. A lawyer and top member of Action Alliance, AA, Nduka Idede, had filed a suit to challenge the constitutionality of the provision, with the Attorney General of the Federation sued as the defendant. Meanwhile, the PDP, which had also gone to court, and the lawmakers who made the law in the first place are threatening to head back to the courts all over again. In short, the last has not been heard of Section 84. So tonight we asking, can the courts strike down laws made by the National Assembly? Is Section 84 unconstitutional? And what makes it so? How is all of this going to end as we approach the 2023 elections? With me to discuss these issues, Mr. Abiodun Aikomo, a legal practitioner and public policy and management specialist. He is currently a special assistant to the President on Financial Crimes Compliance, and he works directly with the Attorney General of the Federation and Minister of Justice. Welcome, sir.
Thank you. Good evening.
Also with me is Mr. Jide Ojo, who is an author, a political scientist, a columnist with the Punch newspaper, and of course, a development professional. You're welcome, sir.
Thank you. It's a pleasure.
Thank you. So before we go on, we'll take a moment of a break, and when we return, we'll jump right into it and bring you all the insights, all the analysis on this vexatious section in the Nigerian Electoral Act, which of course has not even started being in effect well enough, because no election has yet been organized or been conducted under it. We'll return in a short while. Stay with us.
This is Trust TV, documenting the Nigerian story.
Welcome back. This is Daily Politics on Trust TV, and we are discussing new developments on Section 84.12 of the new Electoral Act 2022 with two people who I'm sure are well conversant with the issues. Mr. Biodun, maybe the first question is this act constitutional or unconstitutional?
Well, the question, I think you should narrow it down.
Okay.
If you say, is the act constitutional or not? The answer is the act itself is constitutional, duly passed by the National Assembly and accented by the President. So it is constitutional. But if you have specific questions as to the unconstitutionality, I think that will be...
So is it possible for an act as a whole to be constitutional, but certain provisions of it to become unconstitutional? What will make the body, the whole, constitutional, but the part unconstitutional?
Okay. Every law in a constitutional democracy like we have in Nigeria derives their validity and legitimacy from the Constitution. The Constitution, like they say, is a ground norm that defines all the laws. Every law or every other law derives their life from the Constitutional. And that's why the Constitution is the supreme law. And by itself, it says any other law that is inconsistent with the Constitution shall be void to the extent of its inconsistency. So it is possible to have a law is made up of sections, subsections, like we have seen in every law. So it is possible to have a law with certain sections that are valid and some other sections, for one reason or the other, not valid. So it is possible, in a nutshell, to have a law that will be partly constitutional and to some extent unconstitutional.
So this issue of the unconstitutionality of this particular subsection 12, not the whole section 84, but just this subsection that requires political appointees to first resign before they can vote or be voted for during primaries or congresses of elections. What is there that makes it unconstitutional? What is there that prevents any part of it, or that law from being out of tune, like you said, with the provisions or with the Constitution itself?
Is that directed at me?
Yes.
For me, I do not share the sentiment of Mr. President that the subsection is unconstitutional. And I think the Senate, in its wisdom, has acted on the letter of the president, and has said that there is no merit in it, and as such, decided not to reverse itself by striking out or deleting that subsection 14, subsection 12 of section 84. And I have followed argument both in and out of court. And I've also followed the judgment of Justice Ayadike. Because the section she relies on to declare subsection 12 of section 84 of Electoral 2022 unconstitutional has to do with public servant. And I reliably learned that there have been several decided cases at the appellate court and Supreme Court, possibly, but at least at the Court of Appeal, that says that commissioners, ministers, special advisors, senior special, are not public servants. Because public servants, by its own interpretation, are people who are recruited and have a tenure of 35 years in service or 60 years or whichever.
In other words, civil servants.
The civil servant. But there are categories that are called public servant. They are not mainstream civil servants like armed forces.
Okay.
Members of the armed forces are not civil servants, they are public servants. Because their own regime, their work schedule is not in tune, like you resume work at 7:30 and close by 4. Mark you, even when you look at the way the wages and emolument of these elected and appointed political office holders are paid, as well as those of public servants. One is under the National Income and Wages Commission. The other one is under Revenue Mobilization and Fiscal Commission. So there are two separate bodies that decide what each of them gets. So a civil servant or a public servant is guided by National Income, Wages, whereas the political appointee, like the governor, the ministers, all commissioners, have their wages determined by the Revenue Mobilization and Civil.
Just like the politicians.
God bless you, sir. So when you look at that, you cannot, by any stretch of imagination, now say that it's SSA to the minister or to the president is a public servant, because he holds his office at the pleasure of the governor or the president and can be so removed. A civil servant or a public servant cannot be summarily removed. I don't know if you get my drift. Even if he's committed in the act, a minister cannot sack the PAMSEC, even if the PAMSEC head he has to go through the normal disciplinary procedure as specified in the public service rules. I don't know if you get my drift. But an SSA to a governor or a minister to the president can be summarily removed without any evidence. We have seen President Muhammadu Buhari sacking 2 of his ministers.
In one day.
In one day. Did they go through, was there any hearing? Was there any query issue to them? Did they have to be interrogated or pass through any disciplinary measure? The president just announced on here that you have been dropped.
Mr. Biodun, you said earlier, but he's brought an interesting distinction to the discussion. First of all, that you have 2 categories of officers here, public officers and then the regular civil servants. To one, you have an existing law that the judge has relied on. To the other, they are not included in that. But let us say, you said that the Constitution is the ground norm. So what is there in Section 84(12), as a lawyer yourself, that makes it unconstitutional, that makes it inconsistent with the provisions, any part of the Constitution as we know it in Nigeria?
Okay. Between, Mr. Ujo has introduced, like you said, a new perspective to these arguments. And between Friday and today, we have listened to millions of opinions.
Yes.
Everybody had one argument or the other to say. It is what it is, opinion. And I would like to take us back a bit to the process of getting to where we are today. When this law was sent to the president by the National Assembly, Mr. President wrote to them expressing concern about this provision. And he gave his accent conditionally. It's in the public domain. So, and in the letter of the president to the National Assembly, Mr. President said he had received advice from not only the Attorney General this time around, from all relevant agencies.
Okay.
And it was believed from the content of the letter that the proposed Section 84(12) violates Section 40 on the right to freedom of association and 42 on the right against discrimination. That was the letter of the president. But in the judgment of the court, which is in contention now, the court has now ruled that the provision of 84(12) is what it is, unconstitutional. So we continue to have arguments.
But the court cannot say unconstitutional, and that's the end of the story.
No, no,
it has to give justification
if you read,
for the constitutionality
of
or
course,
unconstitutionality.
court,
and Nigerians can take that apart.
No. The court specifically listed the provisions of the Constitution that is believed that this provision violates. Is in the public domain. Everybody has seen it.
Yes.
So that is the position of the law as of today.
So that means that that part of the Constitution will be deleted. I mean, that part of the electoral law will then be deleted, or has it already been deleted?
No.
By your office?
No.
Okay.
No. Let's get it right. The courts do not act in vain. There is no court that speaks to the air. There was an action before the court, and the court has made a pronouncement, gave a judgment, made a pronouncement, and directed the Attorney General to take a positive act. So after the court has declared the provision unconstitutional, the court went a step further and directed the Attorney General to delete. That is a positive order of the court. The Attorney General is bound to obey the judgment of court.
Thank you. I'll come back to you later as to what this will mean to the National Assembly and to the various copies of the Electoral Act itself, because evidently if that part of the law is deleted, and the National Assembly members are still in contention with it, which version of the law should we have? Are we going to have 2 or more versions of the law? But we will come back to that shortly. Maybe we can look at this, Mr. Jidojo. For example, the first attempt that the president took, was to write to the National Assembly, as Mr. Biodun explained earlier, that he wants that part of the law, the new law, deleted. But the National Assembly members, like you said, they didn't agree to this. There was a voice vote. All of them rejected it. So is this court another attempt to get what they want by other means?
Okay. Yeah, let me put this in perspective. And you see how, pardon my choice of word, this government is, well, let me not say it's the government. The president's advisory did not rely on any of those sections that Justice Ayadike used in nullifying Section 8412. Do you get it? The president did not quote those sections 66, 107, 137, and all of that. That the plaintiff who went to court, the action...
the president did, wouldn't it be prejudicial now?
No, wait.
Okay.
What I'm saying is that the advisory the president relied on did not come, because the interpretation, why there is a groundswell of opinion, and why a lot of lawyers believe that this deletion of Section 8412 is a booby trap for even APC itself, that it needs to be very careful in rushing to implement it, because there is going to be an appeal. I know that filing an appeal does not mean a stay of execution, but I believe by today, tomorrow, we will hear that possibly the interested parties may have filed stay of action and then appeal. But what we need to do, let's harmonize the positions. The president that received an advisory from the Attorney General and Minister of Justice did not cite those sections that the plaintiff went and cited to convince the judge to strike out Section 8412. What did the president say? The president cited only two sections of the Constitution, which is Section 40 and 42. What did they have to do? Talking about human rights, right against discrimination. Now, if the president in his wisdom has been so advised by the Office of Attorney General to say, look, if you allow this to flow, you'll be discriminating against certain category of political appointee, then please look into it. Why would the judge now give a different interpretation, relying on sections that have to do with public servants, asking them to resign 30 days to the election? That is the crux of the matter that will go on appeal. But let's also look at the merit of what the National Assembly, the lacuna, the National Assembly is trying to cure by putting Section 8412. It is to the effect that situations where you are creating uneven playing field in political contestation should be set aside. What's the uneven playing field? A commissioner wants to run for governor. He sits in his office, went and bought form, and starts campaigning to be the governor. Meanwhile, he's still subsisting as a commissioner. And then, after winning the ticket of the party, still stayed put, using the resources. And the resources of the state here may not necessarily mean the fund, but even the time. Time is a resource, isn't it?
Yes.
The time that you are supposed to be doing your official work, you are spending it campaigning. Because what it does now,
wait, Sulaiman,
please let me land on this.
Okay.
Sulaiman, let me land on this.
Please.
I don't want to choke on this thought.
Please, go ahead.
The current Electoral Act says campaign will be for 150 days. If campaign is for 150 days, and you are going to be resigning only 30 days to election, that means while you are still in the office, just like a governor and a minister, a governor and a president, you will be using state resources to campaign. The time, the money, the vehicles, even you may corral the contractors to the ministry to support your political ambition. Meanwhile, those you are competing with do not have those paraphernalia of office. So it is
that too
immoral.
a form of discrimination
It is discrimination against other aspirants or contestants, which is why Lana Sikh, Femi Falana Esquire said, when you talk about discrimination, the fact that if you are not 18 years and above is a discrimination against those who are younger in age. Because if the right to vote is for only people who are 18 years and above, that means you have discriminated against 17 years and below.
I think you get where he's going in his lesson, that some forms of discrimination are unavoidable in a democratic situation, right? Is discrimination against, public officers, public appointees, political appointees.
No matter the line that you want to toe, you always have an argument. Even the cost of procuring expression of interest is discriminatory. How many people have 20 million?
Absolutely.
No, if you want to stretch the argument of discrimination, we can take it to any length. But the law is the law. Okay, is it only political appointee, just for purpose of argument, that can possibly use their time? You relied on time as a resource. What about other people in the other arms of government? If you want to take that argument to that extreme,
for example,
if you are a member
a sitting governor.
Yes. Why not?
It's
the time of the state. If you are in the National Assembly, you'll be frequenting your constituency rather than stay in Abuja. So if it is the argument about you spending time, you using resources in this country, you and I, have you not seen an incumbent being displaced by people outside? So the argument is not, it doesn't mean that when you are an incumbent, you will always win because you are leveraging the office. It doesn't necessarily follow. So the argument for me is neither here nor there.
So, but we have two lines of argument about the constitutionality or other of that. One that which the president expressed, that it is discriminatory. The other is the one that the judge mentioned.
Let me just
that
go.
It is against certain
let me
sections
just go straight to the
point. So which one is which?
Let me just go straight to the point. When the president was writing to the National Assembly, the president limited the concern to sections 40 and 42. Now, the case before the court is not the Father Christmas. The court does not even deal with hypothetical or academic questions. The court deals with cases submitted to the court. I'm not counsel to HDK. I didn't appear in the matter, but it is what everybody has read that I have read. So HDK must have submitted to the court via originating summons. Originating summons is the process whereby you start a matter and telling the court to construct, to interpret provisions of the law and give judgment. So HDK must have submitted all those sections to the court for the court to make pronouncement, and the court has pronounced.
Okay, but the court pronounced based on the idea that the section, grants public servants, that's the right to participate in this process. So are political appointees also public servants? That question must be determined.
You see, that question
is
what the court has determined.
Okay.
People have said it is par incuriam in law. Maybe the court heard or
that
not.
That means what?
No. Maybe it was in error or rightfully so.
Okay.
But today, based on the judgment of the court, that is the decision of the court, which is binding unless it is set aside or it is reversed on appeal. So I cannot sit here and second guess the judgment of the court. I'm a lawyer, I'm bound. Even if you disagree with the judgment of a court, you have to follow the necessary channel, the lay down rule to go on appeal. A lawyer is not allowed to condemn the judgment of a court, even when it is against him. So I'm a lawyer, I will stand by that judgment, which has been served on the Attorney General. That is the law today. If there is an appeal tomorrow and it is reversed, we will be guided But today, that is what we have.
Those of us in journalism would say that when a lawyer speaks like that, it is because the case favors them, isn't it?
No. When you say it favors me,
Yes.
I'm not contesting election.
Absolutely
I
not.
don't
Yes.
have any super interest.
Okay.
I'm just stating the law as it
As
is.
it is.
That
Thank you.
somebody went to court, the court made a pronouncement and directed the Attorney General. Okay, what should the Attorney General do? He should
Because he's
discount-
also sued, actually.
He's a party.
It's a party to the case.
and the Attorney
which
General is
what-
directly
which is
affected by that judgment.
Thank you. Which is, maybe before I come to you, I get to ask this question, which is what part of the issues that people are raising, that the plaintiff is suing the Attorney General, but it's not suing the actual National Assembly that made the law. It's not suing the INEC that is going to enforce the law as far as our electoral system is concerned. How does that work out?
Dr. Suleiman,
Yes, Suleiman is okay.
somebody, there are always two sides.
Yes.
There is a plaintiff and defendant. They are on opposing sides. And the judge is impartial arbiter. AGDK, Anyadike,
Yes, that's the
elected,
judge.
believing that, no, I'm not talking about the judge.
Okay,
Sorry.
the plaintiff.
I won't call the name of the judge like that.
Oh, I see.
The name of the plaintiff.
Okay. Somebody is there. We mentioned it.
Okay.
Go ahead.
In his wisdom, he's a lawyer. In his wisdom, he elected to sue the chief law officer.
Okay.
So there are other parties who may be interested in it, just like you have identified. But those who are the parties before the court, and those who are the judgment of a court is binding on those two.
Would it have made a difference, sir, Mr. Jide Ojo, if INEC and the National Assembly themselves were involved as parties to this case, were included as parties to this case?
I feel so. Okay. And that's why this judgment of Justice Anyadike is raising a lot of eyebrows. Because, you see, I recall the shenanigans that took place before and after the annulment of June 12, 1993 presidential election. Ebun Adegborougha SAN said, may judiciary not kill Nigeria's democracy. It is curious that this whole case was filed and decided within 1 week. You didn't join the necessary parties. You joined the chief law officer, but failed to join NAS, National Assembly, that even produced the document in question. You failed to join INEC, who is the regulator of the environment,
Yes.
and who by Section 82 is supposed to be at every convention, meetings, and all of that. So was it an oversight? This was not
On whose part?
No, I'm not blaming the judge. I'm blaming the plaintiff.
Okay.
That is the plaintiff doing an archaic job to say, as a lawyer, that should know. Because he is said to be an Action Alliance, is a politician,
member, but he's also a lawyer.
and he's also a lawyer. If you are a lawyer, or you even contracted out and said, I gave a brief to a lawyer to sue, you should know the necessary parties that you should join. This is not an ex parte. This is a course of action that you want a determination on something that will be far-reaching. Mark you, let's look at the ripple effect of this. If APC or all the 18 registered political parties chose to rely on this court of first instance to start organizing their primaries without the people who should resigning, because I've seen a memo from the SSG to Kaduna State government asking those who are interested in contesting election to resign in consonance with the provision of Electoral 2022.
Yes.
Now,
Before this court
before
judgment.
the Justice Anyadike's judgment. Now, if you now cite Justice Anyadike's judgment and retain your seat and say, after all, I'm covered, and maybe in April, there's now a a court of appeal decision that overturns Justice Ayadike's own and reinstated the provision of Section 84 sub 12. What do? If it goes on appeal, let's say by May, and the period for party primary is scheduled between April and June. So if by the time the apex court determines and decided that, look, Justice Ayadike erred in law, we have seen situations where court of first instance, the appellate court, and will uphold a position in law only for the Supreme Court to overturn.
All of them.
And that means all that you have built upon that decision comes to a naught. And this will have ripple effect on the preparation for 2023.
So any candidates would then not have been validly elected.
Exactly, because it will not be a case of invalid nomination.
Okay.
That, okay, it will affect everyone. It will only affect those people who are holding political appointments. And mark you, I like the way my brother,
maybe
please,
we can
Sulaiman,
go on a short break.
please bear me, because sometimes I forget this.
Yes.
My brother was stretching something. I've also had this said, that look, when you look at discrimination, National Assembly will also use time. The governor, the president is using time. They are elected. Elected officials and appointed officials are not equitable in law. Because a governor,
or in politics,
even in law, you are elected, like minister, commissioner are not protected by Section 308. They do not have immunity. Do you get it?
Yes.
But a governor has immunity. So these people, this category of people we are talking about, who are political appointees, serve, they are lieutenants to the governor, they are lieutenants to the president. He can drop them like hot potato. If he so wish, he can appoint them in the morning and drop them in the evening of that same day.
So that means they are not so important.
No, they are not so important. You cannot equate them. You cannot equate them to an elected official in the mode of a lawmaker or a governor or a president. That's the point I'm trying to make.
Thank you. So maybe when we return, we continue with this very point. I will give you certainly an opportunity to revise the point in case any of our viewers missed it. Thank you very much for staying with us. We'll take 10 seconds of break. When we return, we'll just continue because it appears that the discussion is just getting hot and even more interesting. Thank you for staying with us. We'll be Welcome back. This is Daily Politics on Trust TV, and we're discussing new developments on Section 84(12) of the Electoral Act. And with me are people whom you might have seen are well versed on these issues. So, Barrister, let me come back to you. One of the issues people raised on this is that the law itself, the original electoral law, was made here and passed here in Abuja. You know that the National Assembly that made it is located right here in Abuja, but someone is going all the way to Abia State to get a job, what you in the legal profession call foreign shopping. What is the wisdom of that?
I think I would recommend that you invite the plaintiff.
Okay.
So that he is in the best position
to say why he went that far.
To answer some of these questions. But every lawyer knows the Federal High Court is one court. Okay. Federal High Court is one court that is sitting in many divisions of Nigeria. So I don't know if the plaintiff lives in Umuahia or what were the factors that led him to the court in Umuahia. But the Federal High Court is one court. He's sitting in Ibadan. He's sitting in Lagos. He's in Abuja. He's everywhere. Federal High Court. So he went to the Federal High Court. You know, we can begin to second guess the reasons, but it's not in my place to say why. But like I said, he went to the Federal High Court and the judgment is effective all over Nigeria.
Thank you. Mr. Judojo, by going that far, does that have any implications to the judgment that has been delivered today?
Of course not. Like Biodun said, it's a Federal High Court and it's one court. And one thing I am happy about this Electoral Act, what it has done is to even bring some measure of sanity to this whole forum shopping you mentioned. Because now pre-election matters are restricted to Federal High Courts alone. Unlike before, where, as the case in Abga, ahead of the November 6th election, where somebody went to Jigawa all the way from Oka, went to Jigawa High Court to procure, no, let me not say procure, to get a court judgment stopping the other faction.
That is happening in Anambra State.
And in an election that is happening in Anambra State. And all of them, you know, at some point, the NJC actually had to call those judges who gave the contradictory and conflicting decisions. But the good news is that the Electoral Act 2022 has limited pre-election matters to only Federal High Court. But the Federal High Court is one court, and being a court of records, it is believed that its decision is binding. The curious thing is what we have highlighted earlier on. Why did he not, or why did Justice Ayadike himself not call the attention of the plaintiff to the fact that he has not joined the necessary parties? Because we have even seen instance, if the fair hearing, and this is the point that I think I need to make.
Okay.
It's about fair hearing. You can't shave a man's head in his absence. The National Assembly that made the law, and even for the first time, Sulaiman, we said it here, last week or last 2 weeks?
Yes, 2 weeks.
That for the first time, Nigerians were celebrating the Nigerian Senate for standing up to be counted that, look, on this point, we are not with you, Mr. President. We bent backward when you raised the issue about mode of primaries, that we need to expand the modes of primaries rather than having direct primary alone. You want us to have indirect, you want us to have consensus, and we have put it there. But on this section 84 of 12, we do not agree with you. I think the principle of fair hearing, at least at the very minimum, should have been that Justice Ayadike should have called the attention of the plaintiff to the fact that you have not joined the necessary party in this suit, and give him opportunity to remedy or rectify that case or that matter. But she didn't do that. She decided to go ahead, and you now have a situation. It did not forget to join the Attorney General. Now, is it even in the position of Attorney General to delete any part of our law? It is not. The court did not say, I've struck it out. I've seen situations in the past. Section 90 of Electoral Act 2006, where just a lordship, Justice Abimbola Oge, struck out a section of that law based on issue around campaign finance sharing among all the. That provision says, as at that time, there was public funding being given to register political parties in Nigeria. So the political parties, now in that act of 2006, it says whatever is budgeted for all the parties that have representation in National Assembly will get 90%, and all the other parties will get 10%. So the CNPP. CNPP was Conference of Nigerian Political Parties under Barrister Maxioku. Maxioku used to be the national chairman of no, not ABGA. Okay. I think Green Party or National Conscience Party or something. Okay. Now, he's one of the... So he went to court on behalf of the Conference of Nigerian Political Parties. And Justice Abimbola Oge, in December 2006, said that provision of that Section 90 of the Electoral Act 2006, if I hope I cited that correctly, but a section of that 2006 Act is in conflict with Section 228 subsection C of the Constitution of the Federal Republic of Nigeria. And if you open the Constitution today, you see that in Sections 228 sub C, it says that funding for political parties will be shared equitably among them. So in that instance, it has happened before. But what I'm saying is that it is unknown to law that a judge will now ask Attorney General to give effect to, deleting a section of the law when those who made the law that should have been mandated to do it are still alive and they are in session.
That's a question that I asked earlier, but let me ask it in a different way now. Please do. For example, if a court has declared a law unconstitutional, which we all agree that a court can do. So if a court declares any part of a law or a whole law as unconstitutional, is there any deleting required again? Isn't that just enough to say this law is unconstitutional? Is there any need to to mandate the Attorney General to that's one. And secondly, could a judge have said, okay, the parties, you have sued the Attorney General here, but parties like INEC and parties like the National Assembly are also important to this case. Could the judge on her own or on his own, could he or she have asked those parties to appear on the court or to be joined in the suit?
Okay. There are different categories of parties to a court action. There are nominal parties, there are desirable parties, there are necessary parties, without who the decision, the suit will be academic. In this case, the Attorney General is the necessary party. The National Assembly, INEC, are desirable parties because they are interested in the subject matter.
But they are not necessary.
In my humble view, they are not. The Attorney General is the chief law officer of the Federation. If there is going to be a suit against the federal government of Nigeria, it is the Attorney General who will be sued. That the Attorney General has prosecutorial, I'm taking it to another extreme now, in terms of prosecution. He has prosecutorial powers over every other authority that is prosecuting, to the extent that it can enter nolle prosequi without giving justification for it. That is the powers that has been given to the Attorney General. We are not talking about a bill. We are not talking about the implementation of this law to the extent that it affects INEC. Somebody has asked the court to interpret vis-a-vis the Constitution, and he has joined the chief law officer of the country. So in my humble view, I do not think that is out of order. Meanwhile, I should say that every judgment of court has implicit in that judgment presumption of regularity. Unless you can show some extraneous things or some positive acts that violated, that will rebut that presumption. So I would say the judgment is regular, unless you have any other thing to say, which is speculation. Now, the court can on its own, the court is not mechanical. The court can on its own, like the lawyers will say, suo motu, consider, okay, for us to have a robust determination of this case, let us add these other parties to it. the court can raise it to the plaintiff and say, join X and Y to this suit, so that we can have a robust argument. If there is an action in court and somebody feels that his right or interest may be affected, he or she will apply or may apply to be joined as an interested party. You file an application to the court to show cause why that decision, that determination will not be properly done in your absence. But okay. In this case, the court, in its wisdom, or in our wisdom, did not deem it fit to so motu join these parties. Okay. At any event, even at this stage, they can file a notice of appeal as an interested party. If they want to,
they are free to do that.
They are free to do that. So that is the position of the law.
Thank you. Just before I go to Mr. Jide Ojo, okay. Because we're just about rounding up now, maybe let me ask you the final question. You just mentioned earlier the powers that the Attorney General has. And I was just thinking maybe that's why that section 8(4)(12) is actually good. If the Attorney General, who is an appointed person, who is an appointee of the president rather than an elected official of government, has this much power, isn't the whole reason that what section 84(12) is trying to prevent, for example, because in this specific instance, there are posters of the Attorney General floated in Kebbi State that he wants to be governor of that state. Would that power match that of any other person in Kebbi State who wants to be governor? Isn't that a good reason why Section 12 should, in fact, be in our laws?
Well, I disagree with you.
Okay.
A constitutional democracy is actually mathematical.
Okay.
The president derives his powers from all the people in a popular election. The president is empowered under Section 5, is imbued with executive powers. That power is vested in the person of the president. They can exercise through ministers and other appointees. So the president then appoints, pursuant to the powers given to him. Now, this appointment is not complete until these persons are screened by the National Assembly, representing all the senatorial zones or districts of the Federal Republic of Nigeria. So they then exercise the powers of the president together with him. Whether or not the current Attorney General is contesting an election, the office of the Attorney General is a constitutional office. Okay. Anybody who occupies the office will defend the Federal Republic of Nigeria. And that is what the current Attorney General is doing.
But if I ask you the same question, what would you say?
Exactly why we should have that Section 84(12). Because, like I said,
yes,
we should not make law for today. We should make it for eternity, for future generations. I've given you a scenario. You are a minister. You are a commissioner. You are a special advisor to the president. You are unelected. We need to emphasize that. Unelected appointee of the federal government. But you want to enjoy the privilege of an elected person by wanting to stay while you use state resources to further your political interest. The law is not saying don't go and contest. The law is not saying you should not even be a voter in your delegate or your party primary. It says just simply resign. Allow someone who is going to be unencumbered, who is not going to be having divided attention. Because, as you have rightly pointed out, the Attorney General wants to run for governorship.
Yes.
So it definitely will be shuttling between Abuja and Kebbi, meeting and ensuring that everything is in order for him to win the ticket of the party. But consider somebody who is not interested in contesting election. He will stay put at his duty post. The other time I was here, I cited the example of Ogbeni Rauf Aregbesola, who, because of his interest in Osho politics, abandoned for 2-3 weeks, did not even attend the Federal Executive Council meeting. And stay put, he was not even contesting. He just sponsored a candidate, an aspirant, into the party primaries of Osun State. And for the whole period, he was there in Osogbo, to ensure the success of his candidate. And we are saying, this is creating an uneven playing field. Because, one, the law does not envisage divided attention from any of his appointees. You are supposed to give your 100%. You cannot give your 100% if, as a minister, you are going to be shuttling, having political meetings where you should attend to serious issue of governance. There are, like he rightly pointed out, it's not in dispute that the office of Attorney General is so powerful. In fact, after that of the president, it is next. It's even more powerful than the position of vice president of Nigeria. Because, like he rightly said, he can file a knowledge. He has done so in the case of Danjuma Goje, that the state is not interested in prosecuting Danjuma Goje again. The heavens did not fall. You understand? But what we are saying is that create that level playing field. We are not saying don't go and contest election. We are not saying don't go and vote in your delegate or in your party primaries, but relinquish that position for somebody who have undiluted. People are asking today, Sulaiman, who is in charge of Nigeria? No fuel. The president is the minister of petroleum resources. There's no fuel for the past 2.5 months. We have been at it. There's no electricity. People cannot sleep well. People's businesses are shutting down. We need people who will give their more than 100% of their time to governance. And that is the unfortunate thing, that in an election eve, governance always shut down. Look at the convention of APC now. For almost 2-3 weeks now, all the APC governors have relocated to Abuja. What is happening now is governance by telephone, by Zoom, by email. Is that how you should run a country that is in desire of development?
I bet most Nigerians will say no, but that is where we have to end today's session. Thank you very much, Mr. Biodun, for coming, Ikomo, for coming on this show. Thank you very much, Mr. Jide Ojo, also for coming on this show. Also, thank you very much for staying with us and our viewers. It is because you are here every night and every day that we also strive to bring you important discussions about how and what is going on in Nigerian politics and how this affects you as the Nigerian voter. Join us tomorrow again for another edition of Daily Politics, and we'll be right here for you. Bye-bye. My name is...